A Brazilian attorney named Dr. Juliano has just done something no lawyer in the world has ever accomplished. He forced a judge to order the Jehovah's Witnesses organization to publicly retract a shunning announcement from the platform of a kingdom hall. This is not a hypothetical. This is not a legal theory. This is a real case with a real verdict that has already been handed down. Right now, the Watchtower is fighting to overturn that ruling in an appellate court, with oral arguments scheduled for April. Dr. Juliano is representing a married couple who left the organization and were immediately subjected to organized social destruction in their own community. He took the Watchtower to court, caught their lawyers lying to the judge, and proved it using the organization's own publications. What he uncovered in that courtroom exposes a pattern the Watchtower has been running in courts around the world for decades. And for the first time, a judge saw through it. Part 1. How the machine works. When someone leaves the Jehovah's Witnesses, the process follows an identical protocol in every congregation on earth. An elder steps up to the platform and reads a single sentence. A specific person is no longer one of Jehovah's Witnesses. That is all the elder says. No explanation, no context, no discussion, but every single person in that room knows exactly what that sentence means. Stop talking to this person. Stop greeting them. If they are your co-worker, speak to them only when the job requires it. If they are your adult child, cut off contact. If they are your elderly parent, the organization's publications have instructed members to refuse even a simple phone call. These instructions are printed in Watchtower study articles, Kingdom ministry issues, and convention talks broadcast to millions worldwide. The organization has built an entire system of social execution activated by a single sentence. And the genius of the design, from a legal perspective, is that the sentence itself sounds harmless. No one says the word shunning out loud. No elder gives an explicit verbal command. The command is embedded in decades of training, literature, and social pressure. This allows the Watchtower's lawyers to walk into any courtroom and say with a straight face that the organization does not force anyone to shun. The instruction is everywhere, but the fingerprint is nowhere. That is the machine. And that is what Dr. Juliano set out to dismantle. The trigger and the letter. The couple at the center of this case lived in a small Brazilian municipality of roughly 18,000 residents. One main avenue, one supermarket, one bank. Everyone knows everyone. Both the husband and the wife had been active members of the local congregation. But this entire legal battle began with a single, supposedly unforgivable act. The wife was spotted entering and leaving a Catholic mass. In a town this small, word traveled fast. She was immediately reported to the local elders. They summoned her to a judicial committee, a secret internal tribunal used to interrogate and discipline members. She refused to attend. In retaliation, the elders made the decision to formally disfellowship her. Watching his wife be targeted by this internal court system, the husband made his choice. He decided to step down and leave the organization with her. But when he did, he took a legal step that most people who leave the Jehovah's Witnesses never think to do. He submitted a formal letter of dissociation, and he included an explicit legal clause. He invoked Brazil's General Data Protection Law, known as the LGPD, the legal equivalent of Europe's GDPR. He formally and legally revoked his consent for his personal information to be used in any public announcement. He had sat in those seats for years. He had heard names read from that platform. He had participated in the shunning himself. He knew exactly what would happen the moment his name was spoken from that podium. The husband put it in writing. "You do not have my permission to announce my name. I am exercising my legal right under Brazilian law." The elders read the letter, and then, completely ignoring the law, they walked up to the platform and announced both his dissociation and his wife's disfellowshipping to the entire congregation anyway. Part 3. The evidence. No one was supposed to see. In most cases of shunning, the damage is invisible. A phone call that never comes. A mother who stops answering the door. The pain is devastating, but it happens behind closed doors where no court can see it. The Watchtower has spent decades benefiting from that invisibility. If there are no witnesses, there is no case. If there is no case, the policy survives. But in a town of 18,000 people, the shunning did not happen behind closed doors. It infected every corner of their lives. They faced explicit, organized discrimination at the local gym, walking down the street, at the bank, and at the supermarket. It happened in public. It happened on camera. And it happened in front of people who had never set foot in a kingdom hall. When Dr. Juliano brought the case to trial, the Watchtower's lawyers used their standard global defense. They claimed the allegations were false and that the organization does not compel anyone to shun. They testified that every witness is entirely free to decide whether to maintain contact with a former member. This is the exact strategy they used in Norway and before the Australian Royal Commission. The playbook is always the same. Say one thing in the courtroom, but print the opposite in the literature. They count on the fact that no one will put the two side by side. But Dr. Juliano did exactly that. He submitted the Watchtower's own official publications as evidence, the same material handed out at every Kingdom Hall. He showed the judge passages that describe cutting off former members not as a personal decision, but as a mandatory act of obedience, where continued contact is framed as spiritual rebellion. The judge now had two things in front of him: the sworn testimony of Watchtower lawyers claiming shunning is voluntary, and the organization's own literature proving it is mandatory. Only one was true, and the judge knew which one. The unprecedented verdict. When it came time for sentencing, the husband made a surprising request. He told Dr. Juliano he didn't want a financial payout. He wanted something no court had ever ordered the Watchtower to do. He wanted them to publicly take it back. He demanded that the exact same platform used to trigger his shunning be used to tell the congregation they are permitted to speak to him again. Historically, the platform announcement is a one-way weapon. The name is read, the shunning begins, and there is no appeal. But the judge ruled in favor of the husband. He condemned the Jehovah's Witnesses and ordered them to issue a formal public retraction to the congregation. For the first time, the weapon was turned against the organization. The appeal that could change everything. Unsurprisingly, the Watchtower has appealed the ruling, with oral arguments scheduled for April. If Dr. Juliano wins at the appellate level, the implications will be massive. A second-instance ruling establishes a binding legal precedent. It means any former witness in Brazil who was publicly announced against their will could point to this case and sue. With nearly 900,000 active Jehovah's Witnesses in Brazil, a precedent here isn't a footnote. It's an earthquake that opens the door for hundreds of similar lawsuits. For those in Brazil considering leaving, Dr. Juliano offered a practical legal strategy. Before submitting any dissociation letter, send it via registered mail with a certified return receipt, known as an AR in Brazil. If the elders ignore your data protection request and announce your name anyway, that receipt becomes devastating proof of liability in court. For decades, the Watchtower's legal defense has survived on the lie that shunning is a personal choice. It worked because the damage is usually invisible and impossible to prove. But in a small Brazilian town, security cameras recorded the physical avoidance. Strangers witnessed the public humiliation of a father and his young daughter. And a lawyer used the Watchtower's own publications to force a judge to see the truth. Forced shunning is not optional. It never was. If the appellate court upholds this verdict in April, the Watchtower's most powerful weapon will suffer a crack no legal team can repair. If you've experienced shunning, do you believe courts should have the authority to order a religion to reverse an announcement? And if you are still inside and planning your exit, does knowing these legal tools exist change your strategy? Let us know in the comments and subscribe to be the first to hear the final verdict this April. At the local bank, the building's internal security system captured exactly how this psychological abuse looks in the real world. The husband was standing, leaning against the exit door. A well-known congregation elder was walking directly toward that same exit. As the elder approached, the husband made a polite motion to greet him. The footage shows the elder's immediate reaction, a bizarre, highly artificial, and exaggerated physical contortion to dodge him. The elder lowered his head and actively swerved to avoid crossing paths. This is a man who once shook his hand every week, now caught on camera treating him as if he were contagious. At the local supermarket, the situation was even worse. The father was standing in the checkout line, holding his young daughter in his arms. He saw a family from his former congregation and attempted to say hello. They blatantly refused to look at him. They refused to look at his child. They stood there in a public checkout line and pretended that a man holding a little girl did not exist. The child did nothing wrong. The child did not leave a religion. The child did not write a letter. But in the Watchtower system, if your parent is shunned, you become invisible too. And here is what the Watchtower did not account for. Other customers with no connection to the Jehovah's Witnesses saw exactly what happened. They saw a family publicly humiliate a father holding his daughter, and those customers later agreed to testify in court. For the first time, the invisible punishment had witnesses who were not under the organization's control.